Okay. Boker Tov, everybody. We begin the 12th parak of Ketuvot. All right, we begin, and we started at today's office Kuf Bet 102. We start at the bottom of Kuf Aleph Amud Bet, the next Mishnah. And now we move from the previous one, which was a lot about, the woman collecting from the estate, the widow collecting from the estate, her negotiating with the orphans, and there how they play that out, selling off the assets. And now we get to the sort of ksuva when the marriage is existent, and the sort of the ongoing obligations of the ksuva. So it's an interesting moving back and forth between sort of the lump sum payment, ikar ksuva, at the end of the marriage, and the questions about the ongoing aspects of the marital responsibilities, like the mizonot and so on, that are called the t'nai ksuva. So this Mishnah gets us a little bit more back to the ongoing obligations, but it really speaks about special contractual arrangements that are not the standard part of the ketuvah, but a woman might negotiate when she comes into the marriage in order to make sure that her interests and her family's interests are taken care of. So let's take a look now at this first Mishnah. Hanosias isha, a man marries a woman. Upaska imo, she sort of arranged with him, meaning this is her initiative. She basically made this following, demand and requirement, the following contractual arrangement. Today she yazonat bita chamesh shanim. She has a daughter from another marriage. And it could be a son, but often it's the daughters that we need more taken care of in that society. And she's coming in with her daughter from another marriage, and this new husband has no legal responsibility to support his stepdaughter. So therefore, she makes him agree, before we get married, buddy, I need you to sign a contract. We'll put this in the ksuva. We'll see in the Gemara exactly where this gets signed and committed to, that you are going to pay for the support of my daughter for the next 5 years. Then she demands it, and he wants to marry her, and he agrees to it. All right? So if that was the arrangement, he's obligated to do it. Now, Nisei, right, it kind of gets to the less obvious in a minute. Nisei Shla'acher. Now, she basically got divorced from husband number, well, probably it's 2, but we'll call him 1. Okay, so she came in with her daughter from, I don't know, another marriage or out of wedlock or who knows where, and she married Reuven. Okay, so, and Reuven agreed to support her daughter for 5 years. Now she got divorced from Reuven, and she married a Shimon. And she said to Shimon, you got to sign off and agree to support my daughter for the next 5 years. So if he agrees, even now remember, Reuven still has an obligation.
Presumably he gets off now, right?
No, let's take a look. Now Shimon has to support the daughter for 5 years. Lo Yomar Rishon. Reuven can't say, you know what? Let her stay married to me and I'll feed the daughter. Basically, I was only assuming I was going to have to feed the daughter as long as we were married. He can't say that. You never stipulated that. You just said you'd feed your daughter for 5 years. You could have said you'd feed a stranger.
So never said as long as we're married, you'll feed.
Right, exactly. You could say you would have fed a stranger's daughter for 5 years. You just obligated yourself. You never said it was limited to the time you were married together. Ella. Now, this girl probably right. This girl is not going to be eating at Reuven's table. She's now living with her mother at Shimon's house. So Reuven has to bring over the food to wherever she is. Now, where her mother is. Now Reuven goes over to Shimon and says, "Buddy, I think we've been had." And then they say, then they're both going to say, "You know what? We both agreed to feed her for 5 years. We'll work it out between the two of us, and we'll make sure she's fed for the last 5 years. We'll split it between the two of us, and therefore your daughter will be fed." No, you can't say that. Each one has an independent obligation. Echad zanah, the echad no saying that the maimon zanat. One has to actually provide the food, and the other, once she has food, she doesn't need extra food, has to pay the cost of the food. Right. Both of them have a financial responsibility to pay for the cost of the food for 5 years, and one does not cancel out the other.
That's interesting. So, I mean, is that depending on like the different economic? I mean, it just said 5 years of food. Like, but how do you measure that?
Yeah, I don't know. So that's all right. So that's a question. What you look at, right? You have to. How would you estimate? That's not the immediate concern of the mission.
So when they make a pledge, does it have to be with witnesses?
So that's exactly what the Gemara is going to get to. Okay. So let's take a look. All right. So Nisei Kabal, Nises. Now she goes ahead and she marries a
His daughter, right?
no, I'm sorry, thank you. The daughter, the daughter gets married. Okay, so Habal knows now. Of course, now that the daughter is married, her husband's obligated to pay for the food and to feed her. So Habal knows in Ramazonot. So she now eats together at the table with her husband. The Hain and these two ex-stepfathers, Nosim Ladmei, they still have to pay the food bill, even though she's already being fed. Mesu now. Okay, so this she's sucking away a lot of money due to these food bills that she doesn't have. This money that she doesn't. It's child's. But now, actually, thinking about it in those terms, right? If a woman gets divorced and the court assigns child support to the husband, and then she gets remarried, right? She still continues to collect child support from her ex-husband, right? I assume, right?
Well, you're talking in our society.
Yeah, the second guy.
The second guy doesn't have a responsibility to it, right? Yeah. Okay. Yeah. So okay, but so yeah. All right. So anyway, and even if he would obligate himself, it still wouldn't change the obligation of the first guy. So yeah.
That the mission doesn't consider like having the clock stop for the first guy until the first 5 years, and then pick it up.
Oh, that ultimately would have been in her best interest. Yeah, but maybe not necessarily. I mean, you put away the money and it's there waiting for you, and right. So.
Who knows? We should get divorced.
Right. Exactly. All right. So now the question is like this. Mesu, now, the stepfathers died. Reuben and Shimon died. Now, what's the halacha when a father dies for his daughters, his own daughters? So you might remember that one of the T'nai Ksuva is that the same way the widow is supported by the estate until she collects her lump sum, her daughters are supported by the estate until they reach the age of adulthood, or basically bat mitzvah, whatever, bagros, naris, bagros, and so on. 12, right, 12.5, etc. We won't get into the details. So this Reuben and Shimon died. So their daughters are now being supported off of the estate. But this girl, their ex-stepdaughter, also wants to be supported off of the estate because she's entitled to 5 years of support. It doesn't matter if she's married or not. That's irrelevant. Okay? What is the relative strength of the claim of the natural daughters to the claim of this ex-stepdaughter? Okay? They both want to be supported off of the estate. So Mesu, thank you. So their daughters can only be supported by unencumbered property, which doesn't, it's a funny phrase. It doesn't mean necessarily property without a lien, but it means property that is in the estate that has not been taken over by somebody else, but that has not been sold. Right, thank you. Meaning, so they can only be supported by property that actually is present in the estate.
We're talking about both daughters?
No, all of their natural daughters, Reuben and Shimon's natural daughters, okay? But the ex-stepdaughter, Nizonos min nechasim mishubadim. She can actually also collect from property that has a lien on it, even property that was in Reuben and Shimon's estate that was sold. Now, by the way, you might say, oh my God, here she is, she has this extra privileges over these girls, but that actually is in their interest. Since the daughters are anyway limited to the property that's immediately in the estate, if there's somebody else competing with them and limited as well, then that's not good for them. So the fact that this ex-stepdaughter actually can collect from the property that's been sold, that she has a lien on, actually, limits the competition. Exactly. Now,
they would have to pay it back.
That might be depending if it's with achrayas. That's a good one. Because she's just like a creditor. Somebody obligated himself to her. She's got a sort of like a debt against the estate. And therefore she's able to collect from anything that has a lien on it, even if it's been sold. As opposed to the natural daughters that collect aren't like, somebody didn't obligate themselves and write it. It's one of the T'nai Ksuva, one of the standard sort of things that's part of the implied marriage contract, either implicit or explicit. And Chazal explicitly said that you cannot collect from property being sold because since the idea of support is indeterminate, right, in terms of like how many kids are you going to have, how long are how many years of support, right? So if I'm buying property off of somebody and I know that he's just got married, right, I'm going to be very hesitant to buy the property if I know that people can come and have liens on it and I didn't even know how much the liens are going to be. You're going to have 10 girls, whatever. I mean, I have no way of measuring and guessing how much those liens are going to be. So therefore, the rabbi said the idea that the daughters can collect from the estate and be fed does not apply to property that's been sold because that's not fair to the purchaser. Okay, whereas here you have a concrete, specific debt. One girl, 5 years, and it's the same way there was a debt out for $10,000. Anybody who's purchasing knows what that concrete debt is, and therefore she's entitled to collect from the property that has been sold. Okay? Now, hapikhin, people who are smart, men, if they would obligate themselves in this way, they would write, on the condition that I will agree to feed your daughter for 5 years as long as we are living together. Right. What does that what cases does that exclude? Divorce. So take a look at Rashi. Kolzman shatimi, below imamut, below otamuti, or agasheich. As opposed to if I die or you die or we get divorced. Any of those cases, we stop the money stops. Okay? As long as we're together, that's when I agree to feed your daughter. All right, very good. Let's take a look at the Gemara. Itmar, it was said. Somebody just says to his friend, I owe you $100. Rabbi Yochanan Amar Chayev, okay, you admitted you're Chayev, you have to pay. But Reish Lakish Amar Pater, Reish Lakish said you're exempt. So now the Gemara says, hey Hidami, what's the exact case? If there were people around and I said to them, hey guys, you be witnesses against me. I'm admitting to Michael here that I owe him $100. So my time is Reish Lakish the kapater. Why does Reish Lakish say you're exempt? We know from another Gemara that if somebody admits to a debt in front of witnesses and appoints them to be witnesses to the fact that he's admitting to this debt, then nobody disagrees that he's chayav, that's considered an admission. Now I have to explain to you that within halacha, one way you actually can create a debt is by admitting to something that doesn't exist. Okay, so if I actually, say I admit to you that I owe you $100, and I do it in a way that it's considered like a legally binding admission, then whether or not that's factually true, you now are entitled to collect $100 from me. That is in law considered to be binding and an admission, whatever the facts actually happen to be.
American law said no.
Really?
I don't know. In other words,
right.
You might think it could.
I don't know. If I said, I admit that I borrowed $1,000 from you on this day at this place, etc., and you have witnesses sign it or whatever, and you admit to it, right? And then you have incontrovertible evidence that it didn't happen. I don't know. Are you still obligated in American law? I don't know. Anyway, in halacha you are. In halacha you are. It doesn't matter whether that actually happened. The fact that you essentially testify to the fact, you can, in monetary matters, normally we say in matters of sort of obligating yourselves in lashes and corporal punishment or whatever, obviously, you can't self-incriminate. But in monetary matters, if you admit to a debt, then that creates that's seen as a legal fact, whether or not it actually is a fact.
Eidim Zimmerman would not don't apply to civil cases at all.
Well, no, they do, right? But they don't apply to your own admission.
So your own admission.
Yeah.
So even if the other guy or he himself, says like, I've been really stupid about it, and then he brings Aiden to perjure his witnesses that supposedly admitted to it.
What? No. If it's about the witnesses, that's different. But if the only thing is that we know that you're lying, or we know we have incontrovertible evidence that those things didn't happen, it doesn't matter. It creates a legal fact. Your admission creates it as a matter of legal fact. Okay. Anyway, but of course, it has to be something that's not just conversation, right? It has to be something that creates it as a real, sense of real formal admission to it. So that means that to tell them, you guys be witnesses on me that I'm saying this. So the Gemara says, so if you said that, why does Reish Lakish say you're exempt? And if you were just talking to guy and said, yeah, I owe you $100, and people happen to overhear, but you didn't say be witnesses against me, then my time is Rabbi Yochanan the Kamachayev. Then we know from other discussions in other places that that's not binding. You're not. It does not become sort of a legally admissible thing. Things you just say in passing conversation. That's not real evidence. Okay. So what's the case where they're debating? So the Gemara says, you did not say you be witnesses against me. Then it would obviously be nothing to discuss. What are we talking about? In a document, he wrote, I owe you $100. So I take out a piece of paper and I write, I owe you $1,000, and I hand it to you. Is that the same? Does that have the same weight of me telling witnesses testify, and be witnesses against me that I'm admitting? The fact that I wrote it down obviously gives that a lot of seriousness and a lot of weight, and I'm providing you with the evidence of that, so that might consider to be sufficient. Now Rashi points out
there's a case of other stuff.
Now Rashi points out it's clear from other Gemaras that if you sign a document, it's binding. There's no question about that. You don't need witnesses to sign. Actually, on some Ketuvot, since we're talking about Ketuva, some Ketuvot actually after the witnesses sign, in Sephardi Ketuvot, they have the groom sign as well.
So what do you witnesses at all for?
What? Well, okay, so because witnesses actually make it a more public document and allow there to be liens, where if it's your own signature, it's not as public, so there are no liens. Okay, but anyway, so I said if you signed it, there's no question. That's a star. Okay, again, it's a star without liens, but it's a star. You didn't sign it. It's your own handwriting. You wrote it. Witnesses saw you give it over. There's no question it's yours, but it's not officially a star. But does the fact that it effectively is an admission in writing, not a star, not a legal document, but an admission in writing, does that make it as weighty as saying Gatemei died? That's the discussion.
This has to be a case where there's no other star, right? Because otherwise you can always claim that this is the star I was talking about.
Yeah, whatever. But yes. I mean, yes.
Without witnesses, it's not a star.
Without witnesses, no. If you have your own signature and no witnesses, but you signed it, it's a star, but it doesn't have liens. It doesn't create liens because it's not enough of a public document. Okay, with witnesses it creates liens, but if it's not signed, even by the animal witnesses, it's not a star, but it's an admission in writing. Okay, so what's the legal what is the status of an admission in writing? So Rabbi Yochanan Amar Chayav. Yomi says you're chayiv. Alima milsa deshtara commandamar lahu atem edim dami. It's powerful. A matter written in a document is as powerful as saying that you be my witnesses. You put it in writing, so therefore it's a real admission. And if we know you said it, and there are witnesses that saw you write it and give it over, or whatever, then you can be obligated. You're exempt. It's not so powerful. Not as powerful as explicitly saying be witnesses against me. Okay, it's not. Now we're going to see, this is all to frame so that we're going to get to our Mishnah. Here's going to be the question. How did this man obligate himself to this woman's daughter? Okay, so he has to feed her for 5 years. My love, we must be talking about some type of a case like this, that he wrote it in a document. Now, why? Like, there could be a million ways. He could have written an official star with witnesses. He could have said it in front of witnesses and said, Ateme die. So what does that mean? So Rashi's, it seems that the Gemara's understanding, I think sort of it was like Michael's sort of joking statement when I read the first line, which is, if you say you're going to feed the daughter for 5 years, you have to feed the daughter for 5 years. Duh. So the real answer to that is, well, it's what's interesting is what comes next, that even if multiple husbands obligated, they all still have to pay. But the Gemara wants to understand that even in this first clause of the Mishnah, there's a chiddush. What's the chiddush if I say I'm going to feed her, that I have to feed her? The chiddush must be, how did you obligate yourself? It wasn't so black and white. Okay, so that's what the Gemara understands. That the way you obligated yourself is not 100% clear. It would have obligated you, and nevertheless you have to do it. It wants to read that into the first clause of the Mishnah. Otherwise, the first clause would be transparently obvious. So it must be you obligated yourself by writing in a document, I will feed your daughter for 5 years in your own handwriting, and gave it over. And we see that type of thing creates a legal debt. Yeah.
Why would I think that legally it might be weaker to obligate myself in a written document than orally?
No, it's weaker, possibly weaker than orally, with specifically designating witnesses to be able to testify against you. You guys, you can witness what I am doing here. I am admitting to this debt.
Fine,
like that formalized or whatever. So the question is writing it down as weighty as that? It certainly is weightier than just orally saying it. You orally say it without saying Atameda, you don't obligate yourself. That's what the Gemara says.
Right.
Orally without Atameda, you don't obligate. Orally with Atameda, you do obligate yourself. What about written?
Gotcha.
That's the question.
Okay. Atameda is like witness.
You be my witness.
Right.
So
orally with no witnesses is nothing.
Right. Or even if people happen to see it, we're not designated. Okay, fine. Okay. So my love, so if the Mishnah tells that you're obligated, we must be talking about an interesting case. We must be talking about a case where you obligated yourself through writing it down in a document without having it be as an actual formal star, just handwriting it in the document. So the Gemara says, isn't that what the case is? And that's why it's a chiddush. So the Gemara says, no, not necessarily. B'shtari psikta. It could be sort of documents of like, I'm trying to come up with an English phrase, but like sort of stipulation documents.
Those are
right? Meaning it's like the type of arrangements that are made. Well, it is like time. The type of arrangements that are made prior to a wedding are called the shtari psikta, like sort of like wedding commitments. Or what did you say? Stipulations. And therefore, it's done in the context of the fact that we're about to get married. And therefore, even things that normally would not be weighty enough to constitute an obligation, because basically you're sort of stipulating, what are your conditions for getting married and what are my conditions for getting married, financial and so on. And then you agree to it and you go ahead and you get married. So that creates the binding nature of that, even though it's not like, it doesn't have the normal mechanisms that would normally be required to create obligation. Let's take a look and then hopefully it'll clarify itself. Rav Gidel, like Rav Gidel says, I'm a Rav Gidel, I'm a Rav. So Rav Gidel says the name of Rav. Kamata notin lebincha. So, the two in-laws are getting together beforehand. Okay, and then they say, when you have the first thing, hey, mom and dad, we're getting married. So they all meet the shver and the shriger, and it's very interesting which languages have words for the co-in-laws. Okay, it says something about the society. English doesn't have a word for that. Spanish does, Yiddish does. Okay, so yeah. So anyway, so the shvers and the shriggers get together, and they make a l'chaim, and after the l'chaim they say, okay, how much are you giving? How much? What are you contributing? Not to the wedding. What are you contributing to this lovely married couple? What do you put it? Kama ato no te'im bincha. How much are you giving to your son? And that he's going to give as a presumably as a ksuva obligation.
And this is written and signed.
What?
This is all written.
Well, let's take a look. Kaf for kaf. All right. Well, contribute this amount. Kama ato no bincha. And how much dowry are you giving your daughter to bring into the marriage? Okay, kaf for kaf. So much. Good. Okay, we work it all out. We agree. Umdu v'kitzu. Then mazel tov. You give the ring. Harei at mikudeshet because this wasn't yet the nisuin. This could have been 5 years before the nisuin. Okay, they went there. Harei at mikudeshet li mazel tov. Hein hein advarim haniknim kin kanu. So those obligations are binding. Hein hein advarim haniknim ba'amira. These are things that become binding just verbal, oral,
with the witnesses.
Okay, that there are witnesses to it. But normally what you would require is some type of a kinyan, the handing over of a handkerchief, a sudar, signing of a star. But because it's about a condition for getting married, and then they went ahead, and it's interesting, not even stipulated by the parties themselves, not stipulated by the groom and by the groom and the bride who are the ones getting married, but it's by stipulated by interested parties, and sort of understood and creates the context under which the groom and the bride are assumed to be getting married with that implicit understanding, right? So you could have said, well, then if those things aren't met, the kiddushin isn't binding. It becomes a t'nai in the kiddushin, right? That's the one way to sort of frame what that context means. But what we're saying is, since they're getting married with that, and those were the stipulations, then the act of the marriage essentially makes those stipulations binding, okay? And therefore, you don't need a normal kinyan. So the Gemara says that's what the case would be in our Mishnah. She said, okay, you want to marry me? You have to feed my daughter for 5 years. Fine, I agree. Good. Here's the ring. Boom. So the verbal obligation is binding in this particular type of a context. Yes.
In this case of the in-laws, it's assumed that they are witnesses to this?
Yeah.
And the same thing with the second case now that you just mentioned.
Yeah.
The husband saying
yes, totally. Because if no witnesses, it could always be disputed what happened. Right. Yeah.
I just want the language here is niknin, is kinyan. Is this a kinyan legally or not a kinyan legally?
It is.
Kinyan amira.
Yeah.
Type of a kinyan.
Right. But not by itself, only because it was in the context of a stipulation of the marriage that then happened immediately afterwards. Right?
And that's a star psikta.
Yeah. I mean, star is funny because nothing was written. Presumably what's happened was afterwards it was written down to record it, okay? But it wasn't that the star actually affected the obligation.
Yes, if there's no Hariyat Mekudeshet after this,
right.
There's no obligation.
Right. So there was no star, there was no kinyan, there was just words. But because the words were stipulations and conditions of the marriage, or prerequisites, I should say, not conditions, and then the marriage occurred with that understanding, then the fact that that made it binding.
So if there is kiddushin and then they don't fulfill the stipulation, it's a mekach tu?
No, so that's what I said. One way you could have said it was that it creates a t'nai on the Kiddushin. That's not the way we're looking at it. Because it's not like the groom and the bride said, I'm only going to marry you assuming da-da-da-da-da, you know. It's that the parents are, so somehow the mechanism works that because that creates their gemar das, that they were willing somehow to let their kids get married, and they did it with this assumption that, you know, or whatever, that shows that they were obligating themselves according to what they had agreed to. Yes.
Does this assume that these are young people, these are people who have not been married before?
When it's about the in-laws, probably,
Yeah,
sure.
Because
sure.
once it's a second
right, then it's their
marriage,
own money, right. And presumably the case in the Mishnah is that the woman is stipulating directly with the groom to be, because she already has a kid. She's on her own now.
and at that point, in that particular case, the groom could say, yes, I'll agree to whatever,
Right.
under these conditions. If
Yes.
you leave, then
Right.
So-
Exactly.
One quick question.
Yes, one last
But
number.
it doesn't actually have to be written down, right? We're just saying that it was practiced.
No, correct. Okay. So, one last. You haven't spoken yet. Go for it.
Is it because we no longer have this Kinyan Kesef that we do this at Tanayim now? They exchange a fountain pen or an
Right.
Is that a Kinyan Khalifin? And because there is no Kinyan Kesef?
Well, Kinyan Kesef would not work for contracts. In general, you would need to do something like a Kinyan Chalipin. But the Tanayim we do now is not exactly.
Kiddushin wasn't a Kinyan Kesef?
Kiddushin was. No, Kiddushin was. But okay. If you just
we'll talk about it.
okay, fine. But let me just at least clarify what the Tanaim are is different. Tanaim are sort of saying when before the Kiddushin, and what will be the penalties if you don't go through with your promise to make sure you're going to marry off your daughter to my son, or vice versa. Okay, so that was ensuring that basically that was sort of like for the engagement period. Okay, there's an engagement period where we said we're contracting to basically marry our kids to one another. Okay, but we haven't done a Kiddushin yet. But we want to make it binding. So we're going to have some penalties if you back out and in the end decide to marry your daughter to someone else, or I back out and whatever, let my son marry someone else. That's what the Tanayim was. Now we're actually 3 years later, we're living up to that responsibilities, but now we want to say, but before it happens, what are we going to contribute to the marriage? That's what this is talking about. Okay, and then we make a commitment what to contribute and to put into their bank account and buy them an apartment or whatever we're going to do, and then they get married, and that commitment now becomes binding. Okay, so let's take a look. Okay, now we're going to show Toshma. So now we're going to still try to figure out this idea of a written obligation. Kosev l'kohen, a person has to do a pidyon of his son, which is 5 slaim. So he writes to a kohen, Shani chayev l'cha 5 slaim. I owe you 5 slaim, and hands it to the kohen. He doesn't give him the money. Okay. Now he didn't before the IOU specifically owe this kohen. He could have given it to any kohen. So maybe this constitutes a giving of the 5 slaim, because now I owe you specifically this and that. I gave you the IOU. Okay, I owe you 5 slaim. Chayev lita lo 5 slaim. So thank you very much. You handed him an IOU. You owe him 5 slaim. But no, ain't no padoi. But you didn't redeem your son because you didn't give him any money. You just gave him an IOU. Okay. So the Gemara says, what do you see? So you see that saying IOU, 5 slaim, creates a debt of 5 slaim. And it just says you wrote it down. It didn't say it was a star. It didn't say you signed it. It didn't say there were 8 of them. So you see it creates that debt. It seems like a simple IOU creates a debt. So the Gemara says no. Shani hasam de meshubad leimi dioraisa. No. There it's different. There it's easier for an IOU to create a debt because there is a debt of 5 slaim.
So it's not to this
now, not particularly to you, but the fact that there exists a debt, right? The problem is, here's the problem. Is there enough sense of weightiness and gemar das to my act to obligate me when I just write it? Again, nothing happened that I really do owe the money. I didn't say atem eidai. I didn't sign it. Is there enough weightiness to that act to create that obligation? What the Gemara says is, if there's a pre-existing obligation of 5 slaim, even if not specifically to this one, and you designate it by writing IOU, then that's weighty enough. In that context, that's weighty enough. But that doesn't prove what would happen in a vacuum, whether such a thing would be weighty. So the Gemara says like this: Shani hasa. He says the Gemara, if that's true, amai kasav. If you already own the money, why do you have to write the IOU? No, today levar lo kohen, to designate which kohen you're giving it to. Okay, so that's what's this meaning of it. But it was a thing that had weight because there was already a debt out there. You were just specifying who the debt was going to be paid to. Okay, so the Gemara says, Ihachi, no, am I eno padui? If I really have now said that you are specifically are entitled to it, why is my son not
Well, that's pretty
redeemed?
obvious.
Now that's it is pretty obvious, and it's funny that the Gemara doesn't give the obvious answer. The obvious answer is
You give him any
because you just still owe him the money. You might have now created the debt specifically to him, but to do a pidyon, you actually have to give him it. You don't actually just have to owe it to him. Okay, so the Gemara has
That
a
would solve
strange.
kidnapping problems a lot.
I owe you.
Yeah.
So the Gemara says to the Ula, like Ula. The Amar Ula says, Dvar Torah padui l'chashayitain. You know what? You're right. If you actually now satisfy your IOU and pay up, then you actually fine. We'll have, we'll have redeemed your son. Now, but the problem is the Gemara thinks the language beno eno padui means not just he's not eno padui when the IOU is given over.
Ever.
It means that even satisfying the IOU, he would not be padui.
Right.
So the Gemara says, why not? And here you understand why the Gemara is shifting. If you say the IOU is an independent debt having nothing to do with the pidyon obligation, so fine. I obligated myself to some random Kohen. I paid off my debt. It has nothing to do with the pidyon. But the Gemara says, no, you told me the only reason the IOU works is because it's in the context of the debt that exists for pidyon. So therefore, it is the debt of the pidyon. So if when I'm saying Michael IOU, it's not an independent debt. It is the pidyon obligation that I'm directing towards Michael. So when I pay it up, I should have done the pidyon, and my son should be redeemed. Okay, so why is he not redeemed, presumably even after you've paid it? Someone says, you know what, you're right. When you do pay it, he is redeemed. When you pay it up, he is redeemed, because it is the pidyon debt. Why do they say the son is not redeemed even when you pay it? Because people will see, look, it was the time to do the Binyan Ben. We had the whole big Su'uda there, and he handed him over an IOU. So the Gemara will think that you can hand over IOUs, and that is the act of pidyon.
You're really
they won't realize that the pidyon, right?
So you really can't do this at all.
Well, you can. You just won't be Yotzei Pidyon. You'll have to give another 5 slime to be Yotzei Pidyon. Okay.
Oh, independent of this.
Yeah.
Okay. All right.
Okay. Yeah, it's not like there's
Okay.
never
Oh,
Padua.
just means through this way.
This way,
Okay.
right?
Okay.
Right. Okay. So that's why. Fine. Moving on. Amar Rav Kitanoi. This question of writing an IOU is like a debate. Whether you obligate yourself is a debate of Tanayim. Arev hayotzei achar chitum shtarot. So you basically are a guarantor, okay, and you sign after the witnesses sign. So basically, there's a document that Michael borrowed $100 from me. Witnesses sign it.
You still owe me the 5.
And then Bobby comes, then Bobby comes after, underneath the signature of the witnesses, and Bobby comes and writes, if Michael can't pay, I will guarantee the loan. Okay, and that's what you wrote after the witnesses signed.
Usually it's done before.
Are you right? Normally it's done before. Okay, Bobby writes in, he'll be the guarantor, and then the witnesses sign on the whole thing. But here the witnesses signed on the fact that Michael borrowed $100, and then Bobby wrote down afterwards that she'll be the guarantor. Okay, so what's the halacha? So if I now have to go collect from Bobby because Michael's defaulting, I can collect from money she's got in her estate, but I cannot go ahead and collect from property she sold. I don't have a lien. Why don't I have a lien? Again, in order, you need a witness document to make it a public matter to protect the potential purchasers. You need it to be a public document in order for there to be liens. So the first part of the document is the public document, and I have liens on Michael's property. Bobby's signature, it is binding. It is a good document. I'm entitled to collect from Bobby, but because it happened after the signatures, it's not enough of a public document. That part of it is seen separate from the rest, and therefore I cannot collect from people that purchase property off of Bobby. Okay, so that's what. So that, but basically, I can collect from Bobby. Okay, so that Amarlo Lama. I'm sorry, did I skip a line?
Yep.
Yes. So a story like this came to Rabbi Yishmael. He said exactly this. Fine, you can collect from the guarantor as long as it's property that she has currently in her possession. So Ben Nana said, you can't collect anything from the guarantor, not from property that she sold and not from property that's in her possession. Amarlo Lama. So Rabbi Yishmael said to him, why not? Amarlo, he said, let's say somebody was strangling his friend in the marketplace. What a friend. And somebody else came and said to him, Hanachlo, No, stop strangling him. I'll give you $100, just leave him alone. Potter, you don't have to give him the $100. Okay, Shelo, emunato hilveu. You didn't, now it's a very bizarre mushal and a nimshal, because you would think that actually that's like the nimshal you would think to that is, I don't want to lend Michael the $100. Bobby comes along and says, lend Michael the $100. I'll guarantee the loan, right? So I'm sort of like strangling Michael and that I'm holding off the money. And then you're doing this in order to get me to do something. You would say, well, that's not a real commitment. That would sort of be the nimshal you would think. Somehow the Gemara says, no, the nimshal is after Michael has borrowed the $100, you then come and obligate yourself. I don't understand what that has to do with me strangling somebody and somebody else committing to get me to stop strangling somebody. I've already lent him the money. I just don't get the mashal and the nimshal. Somebody could explain this to me. But anyway, forget the mashal. Forget the mashal. Somebody will tell me what the mashal means. But here's the law. The law is, the real point is, shelo al emunato helveyu. I did not lend Michael the money because I trusted Bobby would pay it. I lent Michael the money before Bobby had signed on as a guarantor. Now, she might have said it to me verbally, but I don't care what's verbal. I care what's in the document. And the way the document presents itself is that I first agreed to lend Michael the money. I lent him the money. The witnesses signed. And then afterwards, Bobby said she'll be a guarantor. So her promise, her commitment, was not a condition of the loan, and therefore it is not really a seriously binding commitment. If she did it to get me to lend the money, then she was seriously obligating herself and seriously making that commitment. It was afterwards, who knows why she's saying it. So it's that's somehow the nimshal. If I say, give him the money, I'll stop choking, there's other reasons why I'm saying it. I'm not really serious, okay? So here also she's not serious. Again, I really don't get the mashal and the nimshal, but the point is, if it wasn't a condition of me to lend the money, then her commitment is not a real commitment. Yes?
So you're saying then that this is not the situation where you were being strangled and I said, don't worry, I'll cover
Right.
the loan. This is just you've chosen to.
Yeah, again, I don't get the comparison to the case of being strangled in the marketplace, but what I do get is that what it's saying is that if you sign after the loan has been made, then you're really not obligating yourself, because it really wasn't a condition.
Maybe it has to do with public humiliation, being strangled. In other words, you're a really close relative, but you're cheap.
Right.
And Michael is a good guy, and everybody loves him, and he needs the money, and he comes to you, and you are like giving him a hard time. But all these people are looking at you, and you're supposed to feel like you want to be respected.
No,
So
I'm being
feeling-
strangled.
So you're being strangled.
That's interesting. I'm being strangled and forced into it.
In an environmental way, and so you feel.
That's interesting.
And then I say, look,
Right.
don't be such a hard guy. Give him the money.
That's interesting.
And I'll back.
It's interesting. I have to think about that. You're right. It's an interesting way of making the of doing the analogy. Yeah.
Is the guy strangling in the shoot because he's trying to recover a debt? In that case,
That's
it's
what
exactly.
I didn't know.
Oh.
Exactly.
Oh.
No,
He's not saying, I'll give you the money if you don't strangle him. He's already in the act of strangling.
Right. No, do you want your money back?
Oh,
you want your money, so you're strangling for the money. So she comes along and says, I'll cover it.
I see. So I am strangling Michael
To get your money.
because basically he already owes me the money.
No,
I would have said it a different
now
He owes
I
you the
got
money.
it.
He's trying to get
All
you to
right.
extract the money.
See, that's why we learn together, so you can tell me what this
I don't
means.
get that.
Okay.
Michael's asking
It
for
means
money.
I already lent him the
you
money.
lent him the
No.
money.
I lent him
Where's
the
my
money.
Pay
The
me
witnesses
back.
the
Pay
witnesses
me
signed
back.
it.
Pay me back.
The
So you
witnesses
come along
signed
and
it.
say,
So he already owes me the money. Now I have him in a stranglehold because I'm going to force him. So you're not going to promise to loosen that stranglehold,
I'll
but
cover
it's
it. I'll
really.
cover it.
I see.
Are
Okay.
you obligated? when you
I
say
see.
I'll
All
cover
right,
it?
fine.
Tell
All
me
right,
no.
I got it. Thank you all very much. Got it. Okay, anyway, Benaz basically says, if it's an obligation created after the death, after I've got Michael in the stranglehold, then it is not a serious obligation. Thank you. Now it makes a lot of sense. Okay, so Gemara says, Lema. Now it really seems what they're debating is how, much Gemar Das, when the Ariv promises to do it, how serious is the Ariv about her, about her commitment. But here's the question. Why should I care how serious she is? She signed the document. Right? Why do I need some extra proof that she's really serious? You signed the document. You wrote out, I'll pay, I'll be the guarantor. You wrote an obligation on paper. You wrote the IOU. That's what we're talking about. And nevertheless, Benana says that's not enough. I need there to be special conditions to obligate her. It's not enough that she wrote it on the document. So the Gemara says, so here you got it. Lema Rabbi Yochanan, Damak Rabbi Shmuel. Rabbi Yochanan says you're chayav. Says like Rabbi Shmuel that when you sign the document, that's enough, even though it came after the loan and even though there were no real special conditions. Reish Lakish, Damak Ben Nanis, and Reish Lakish says like Ben Nanis that no, it's not enough to sign a document. Only when there are really special conditions, like signing it before the loan was made. But normally, just because she signed it, that doesn't obligate her. So the Gemara says like this: I leave the Ben Nanis Kuliyam Lo Pligi. According to Ben Nanis, you're right. There's no question that according to Ben Nanis, simply signing an IOU does not obligate you. You need the special conditions, and that's why it's only when the RA signs before the money is lent.
Or witnesses.
Or witnesses, right. Keep pligi, I'll leave it to Rabbi Shmuel. The question is whether you can prove something from Rabbi Shmuel's position. Rabbi Yochanan, Rabbi Yochanan says, yeah, I hold like Rabbi Shmuel. Rabbi Shmuel says signing a document is enough. Or not signing, writing a document is enough. Writing an IOU is enough. And therefore, even though it came after the money was lent, and there are not special conditions, when you wrote it, you're obligated. And that's what Rabbi Shmuel says. Reish Lakish would say, no, you cannot extrapolate from Rabbi Shmuel's case to the general rule. There's already a debt that exists. Where does the debt exist? Michael owes me the money. So when Bobby signs on afterwards, you're just extending the debt from Michael and you're being included in that debt. Okay, but the debt exists. So yes, you signed it, but it's a special case. Even though it came after the money was lent, it's still a special case. Sort of like when I owe some Kohen 5 sla'im. When there's already some debt out there, then writing a document can obligate you. But that does not mean it can obligate you in a vacuum. Why does writing a document obligate you by the case of the guarantor? Because there's already a real debt out there, just like by the Pidyon Ben case. And so therefore writing the IOU essentially includes you in that debt. But in the case of a vacuum, then no, and just a simple IOU would not obligate you. Okay, so we have two cases where an IOU obligates you, the Kohen and the guarantor, but both of those are cases where there was some debt out there to begin with. And we have our Mishnah, but there's no clear indication that our Mishnah is talking about a simple IOU, and our Mishnah might be a special case because it was a condition and a stipulation prior to the wedding. Okay, now we're going to go back to the statement of that stipulation prior to the wedding. Let's take a look. Gufa. Let's go back to that statement we quoted earlier. Amar Rav Gidol Amar Rav. Kamato notein lebincha. How much are you giving your son? Kach v'kach. So much. Kamato notein lebitcha. How much are you going to contribute to your daughter? Kach v'kach. Okay. Amdu v'kitzu. Then the kids got up and they got married. Kanu. Then it's binding. These are the things that become obligated, contractually obligated just through words. Amar Rav, Mistavra Milsa Rav, that statement of Rav makes sense, Bevito Nara, when the guy is marrying off his daughter, who is a Nara, or let's say a Ketana. Why? Because he at least is getting some benefit from it. He's at least pocketing the Kesef Kiddushin. And therefore, the fact that he's getting benefit when they get married, that creates, it says, in exchange for this $1, I obligate myself, etc. There,
I guess it depends on what she's getting in return. You're not getting any benefit.
That's what's going to in order to create a Gemar Das, this is even in secular law, right? You need to, there's some sense of you got something. To obligate your sense in a vacuum is harder. So that's normally why, the normal sort of chalipin we do. I give you my watch, I give you my handkerchief. You get something that creates, it's a formal act, it formalizes it, but there's also some sense you get that creates the Gemar Das of you to commit. So the Gemara says it's tangible. The Gemara says, okay, so that would be true if the father of the daughter pockets the Kiddushin money. Then that's the thing he's getting that obligates himself. Aval bevito bogeret, aval bogeret lo matan al yadei, but if she already is after 12 and a half, that she's pocketing the money, the ring, lo. So the Gemara says then he would not have said it. Then there's not enough to create the commitment. A minute. So the Gemara says, Elohim, in God's name, Amar Rav afilu bogeres. No, Rav would say it even when the daughter was already a bogeres. If you don't say that, Avia ben how about the father of the son, right? He doesn't pocket anything. His son marries this girl. He's not getting anything from it. So clearly, you don't need to receive anything when the in-laws obligate themselves. It's just the words. the words followed by the act of kiddushin. But they actually did receive nothing. Okay, they got nothing tangible and physical. Certainly the father of the son got nothing tangible and physical. So the same way the father of the daughter does not need to get anything either. Just the fact they got married creates the kiddushin. But now the Gemara,
something tangible.
the woman. So the Gemara says, but the father doesn't. So the Gemara says, the Avia ben my hana asliyabe. Ella the kamichatni hadadi. What's the thing they got? They got the pleasure of the fact that they got their kids married off. That's the pleasure, okay? That creates the, the commitment, the gemar das, the necessary intent. Not what is it like the meeting of minds? I'm missing the right legal phrase here, but anyway, but that creates the obligation. So the consent. Okay, so anyway, or not consensus. Anyway, forget it. Anyway, that creates the obligation. All right, so what does it is you made the agreement, they went ahead and got married based on the stipulation, and therefore, and because you wanted them to get married, and you were making the agreements in order for them to get married, and then they did get married, so that creates the fact that they did what you wanted and were trying to get accomplished, and they did it, that you received that benefit that you were trying to achieve, that creates the obligation. Okay. Amalei Ravina Ravina said to Ravashi, Dvarim halalu, no, we're going on. Dvarim halalu nitnu likaseh v'lo nitnu likaseh. So when you go ahead and you make an oral commitment, right, like these conditions before the wedding, okay, can you go ahead and afterwards put them in a document? Now, of course, you'd want to put them in a document. You want to remember them and be able to, commit somebody to them, okay? But the question is going to be, what's going to happen? Because if you put them in a document, is then it going to lead to the question about being able to have liens and are be able to collect, and so on? Because again, wasn't really like a public matter that originally was put into a document that would create liens. So can you put into a document afterwards? So let's take a look. No. These types of things that basically were verbal and did not start as a document, you cannot go ahead and convert later into a document with liens, because it's not how they started their lives. Okay, that makes sense. But Amar Lei, so Asfi, I'll ask you on this. Our Mishnah, it says that the smart people would write, I'll feed your daughter as long as we're together. But we're now focusing not on the as long as we're together, but would write. You see that this stuff is getting written down. So the Gemara says, no, my kosfin omrin. Doesn't mean that they wrote. It means they would say. So the Gemara says, Kari leila amira ksiva? You would call just a verbal obligation writing? Yes, that's not. Hakosiv l'isha, if a man writes to his wife, Din v'dvar mainly b'nichsayich, I waive all my rights to your property. Tani Rabbi Chia, ha'omer l'isha, and Rabbi Chia says, even though it says if you write, it means if you said. All right, so that's a bit of a stretch. But the bigger question is from the beginning of the Mishnah. Tashma, come in here. Ain't kosin shtari erisin v'nisuin elamidas shneim. I'm sorry, not that. We'll get to the beginning of the Mishnah in a minute. You only write documents of erisin and nisuin, meaning the stipulations, presumably, of that they made in order to do the kiddushin. What we're talking about, only with both of theirs, consent. So the Gemara says hamidas shneim. But if both sides consent to be written down as a document, kosin, you write it. My love, shtari psikta. Aren't we talking about exactly these type of verbal stipulations, and that if both sides agree afterwards, you can actually convert it into a document? Someone says, "Lo, stari erisin mamish." No, we're talking about actually a document that is given to effect the kiddushin, not the financial aspects, but the actual shtar kiddushin itself, which we don't have. But there is a way that you can marry not with a ring, but with a piece of paper. How do you marry with a piece of paper? To the Rav Papa, like Rav Papa's Rav Sharvia. The Itmar was taught, I wrote, basically, I took out a piece of paper and I wrote on the piece of paper, Harei at mikudeshet li, no betabat zo, just Harei at mikudeshet li, and I gave it to the woman. That's Kiddushei Shtar. Now, let's say you wrote it, Lishma, I wrote it with this woman in mind, but she was not party to the writing. It wasn't like she didn't, she was not, it was me doing it unilaterally. It was not with her awareness. Is that a legitimate shtar? And then I give it to her. Then she accepts it, but it wasn't written. It wasn't written with her participation. Rabbi Rabbeinu Amri Mikudeshet, it's a good shtar. Rav Papa Rav Shavaya Amri Eina Mikudeshet, she's not. So when it says you can only write Shtari Erusin with both sides agreeing, it does not mean the financial obligations. It means the document that says Hareyat Mikudeshetli. If you want that to be how you're going to marry your wife, she has to be a party to that writing. Now, it doesn't explain what the phrase Shtari Nisuin means, because Shtari Nisuin, there's no documents for the Nisuin. Then you just get that, presumably, but maybe they'll say that means like the Ksuva.
So no
not the
surprise
stipulation.
engagements then.
So what? Yeah. So the Shtar Kiddushin has to be Midas Shneim. The Ksuva has to be Midas Shneim. But these verbal stipulations maybe are not able to be written down. So that's still the open question. We haven't proven that the verbal stipulations that precede the Kiddushin can be converted into a Shtar. So let's take a look.
Same thing would be with Kesef, Hareyat Mikudeshetli. He throws a ring to her and she just catches it.
No. This is specifically
Just the
about the Shtar Kiddushin. Okay, so the Gemara says like this. Rabbi, okay, so Toshma coming here. Mesu, now we get to the part of our Mishnah which is very clear about that there is a Shtar. Because it says, if Reuben and Shimon died, B'noseiim, their natural daughters, Nizonis Minuchasim B'nei Charim, are supported by the property that's in the estate. He and the stepdaughter they obligated themselves to, Nizonis Minuchasim Mishubadim. She has liens, and she can collect from property that was sold. Because she has an outstanding debt. So she has liens, right? It's very clear in the Mishnah. The girl has liens. How did she have liens? If it started as an oral obligation, obviously the oral obligation was able to be converted into a shtar. So the Gemara says, oh, no. This would be a special case. All along we've been saying our Mishnah was an oral stipulation that then became obligatory because it preceded the Kiddushin. The end of the Mishnah that's talking about liens, that'll be a classic shtar. That'll be a case where there was actually a kinyan and a classic shtar. That's not what we were talking about until now. All right. Which is probably, by the way, the pshat of the Mishnah. Pshat of the Mishnah probably is it was a classic obligation, a classic shtar. But then we wanted to make the whole Mishnah being about this oral thing and these stipulations prior to the wedding. Then we saw in the end that, oh, look, it has the normal power of liens of a shtar, so that's fine. It's a classic shtar. All right. So anyway, Shekana Miyada. Ihachi says Gemara, Binos Nami. So how about their natural daughter? Why don't they have a normal shtar? No. He only made a normal shtar to the stepdaughters, not to his natural daughters. My piska. Why do you divide it? Like, what would be the logic that he would make a shtar to the stepdaughters and not his normal ones? There's an obvious difference. The stepdaughter was a special obligation, and he was being sort of not forced, whatever. He negotiated that he write a shtar. His obligation to his daughters is a standard obligation. He didn't need a shtar. Okay, so my psikta ihi the habe b'shas kinyan mahanila kinyan. So the stepdaughter was around when the mother was stipulating on her behalf. So therefore, he would have done a kinyan. But his own daughters, the lo habe b'shas kinyan, weren't around when he married their mother. Okay, his natural daughters, they did not exist yet. So lo mahanilu kinyan, he cannot obligate himself to them. The other side isn't there yet. It's just the mother. So the Gemara says, how do you know that's always the case? Milo askinan, I'll give you a case where he can obligate himself to his natural daughters. How can he obligate himself to his natural daughters at the time he's marrying the mother? So he divorced her and remarried her. Okay? So, Milo askinan, the have b'shas kinyan. The heichi dami, what would be the case that his natural daughters would be around when he's marrying the mother? He go to Girsha v'hadra. He married a woman, had natural daughters, divorced his mother, and then remarried. So the second marriage, he's obligated to his natural daughters. Okay, so it's possible.
As if they were right. As if they were daughters of another woman.
So why wouldn't there be a shtar in the case of natural daughters? So Gemara says, Ella, here's the real answer, which we could have guessed at the beginning. Ihi, the lesser Batanai based in the the stepdaughter that he's not obligated to by the conditions of the court. It's not a automatically imposed obligation. Mahani Lakinyan. A kinyan will help. Not only will a kinyan help, but also that's why you have to make a kinyan, because you're accepting a new obligation, and so therefore you're going to make a separate kinyan in order to do it. But note, the daughters, which you already have automatically obligated to in terms of your natural daughters, lo manilu kinyan. Doing a kinyan would not help. Really, would it help? Why would it help? I mean, just because I'm already obligated, I can't make it an additional obligation. The Gemara says, migragari, what? It's worse because you have an obligation. No, Allah, here's what we mean. No sub, here's why. you don't have a star for your natural daughters. The Isnu b'tanai Beis, since they are obligated by the court, emat shrare atfasinahu. So this is interesting. Again, I would have just said that it means that in a normal case, you're not writing a star to them. The Gemara seems to be insisting that even if you wrote a star, since the Mishnah seems to be categorical, the Mishnah is saying your natural daughters will never have a lien on property. They can only collect from these. Why not? Why can't I obligate myself to my daughters? So it actually says no, in some ironic way, because you have an outstanding obligation to them, and it's a heavy obligation, the people who purchase the property could always basically say, I don't believe that the father has not already made like a trust for you. That obligation is a strong one. You have no right to come and collect this because there's a presumption that he would have made whatever necessary arrangements to take care of you. Very strange, right? But anyway, the simple explanation is that either one, what I told you before, which is that there's no finite amount to it, but it's okay. But if there is a finite amount, it's an actual live natural daughter that I write a very concrete amount of an obligation to her, 5 years to my natural daughter. Logically, I would say that case, you actually would create liens and you would be binding. Mm-hmm. And the Gemara is saying, no, natural daughters never, because we're going to presume that the father made arrangements. I mean, at least the purchasers can always say, I'm going to presume, I suspect the father made arrangements. You can't prove that you have a right to collect from me. Bottom line is, what did we say? We said that in our Mishnah, the obligations can become totally verbal, but become real obligations because they preceded the Kiddushin, and then the Kiddushin makes them binding. We have an outstanding debate, what happens if somebody just writes IOU without signing it? Does that become a binding obligation? And the end of the Mishnah that says that the stepdaughter has an actual lien, that would be a classic shtar. Not verbal, not a simple IOU. You do a kinyan, witnesses testify to it. That's a classic shtar, and that would have the liens, and that's why the stepdaughter can collect. All right. We end. Wow. What